Dr. Bandy Lee that is with us today, and she's going to be talking about the psychology and family law. So welcome, Ms. Lee. We appreciate you being here. Go ahead and state your name for the record, and then go ahead and proceed.
Thank you so much for having me. My name is Bandy Lee. I am a forensic psychiatrist and violence expert from New York City. What I have to say will be stark, but I've seen a lot in my 25 years of experience being an expert witness for the courts, mostly criminal and civil courts, about 50 of which have been in family court across 22 states. I'm also president of the World Mental Health Coalition and co-founder of the Violence Prevention Institute. I was a research fellow of the National Institute of Mental Health and taught at Yale Law School and Yale School of Medicine for 17 years before recently joining the Harvard program in psychiatry and the law. In 2007, I co-authored the chapter on violence against children for the UN Secretary General, and have also authored other violence prevention documents. I'm a recipient of the National Research Service Award and author of the textbook Violence, as well as of over 100 scientific articles and chapters, mostly on violence prevention. For clinical practice, I work in maximum security prisons and specialize in treating violent offenders. When I became aware of the situation in family courts, I had had 2 decades of serving as an expert witness in criminal and civil courts. I may never have learned about them but for my sister's divorce in Bergen County, New Jersey. Since family courts, as a rule, do not like qualified experts, especially independent experts. None of my previous experiences prepared me for what I was to find in family courts. Yale Law School's Robert Cover said, "Interpretations in law constitute justifications for violence. Nowhere does this seem truer than in family court, and the application more arbitrary, unjust, and unnecessary." Family court judges were granted almost unlimited discretion with the law so that they might exercise benevolence. But without transparency and accountability, their courtrooms have become veritable centers of human rights violations. Much like the prison system I have studied, which is another secret institution that conducts its affairs behind concrete walls with little oversight, brutality and violence flourish in the family court system behind court seals and judicial immunity. I would suggest that the combination of near unlimited discretion behind closed doors and immunity are a dangerous mix. It must be noted how prevalent family violence is. 1 in 2.5 women and 1 in 4 men experience physical violence from an intimate partner in their lifetime. 1 in 4 children experience child abuse or neglect in their lifetime. Over half of female homicide victims are killed by current or former male intimate partner, and more children die at the hands of their parents than any other relationship. It is therefore unsurprising that a vast majority of contested custody cases are actually family violence cases. And they involve some of the most dangerous individuals our society produces. To deny, or worse, to exploit family violence for profit can therefore be very dangerous, even deadly. Around 75% of fathers who fight over custody in family court abuse their children. Many go on to kill, such that almost 1 in 8 of the nation's child murders by parent could be reduced if family courts did not have a role. This can only be an undercount, as routine record concealment makes it virtually impossible to track the true numbers of child murders family courts facilitate. For every child murder, there are at least as many child suicides, and for every death, close to 100 children are injured to the point of needing medical care. Family courts label these cases as high conflict, but the actual situation is usually one-sided, with a criminally violent party using this alternative court, not only to escape prosecution, but to frame the innocent victim. Having treated violent offenders in maximum security prisons as a specialty, I can tell you this is a perpetrator's dream come true. So you can imagine how violent individuals congregate in family court. Indeed, by circumventing due process and placing the force of the law behind family violence, which brings in revenue, family courts have become centers where violent criminals can darvo, which in psychological parlance means deny, attack, and reverse victim and offender. How does this happen? First, if child abuse is alleged or suspected, custody is transferred, sometimes immediately, to the abuser. According to some studies, this happens about 3/4 of the time, but in my experience, it has happened 98% of the time. I will use my sister as an example, but the methods are astonishingly consistent across the country. My sister was on her authorized weekend to be with her children, and suddenly 5 policemen raided her and seized her children based on a court order that was issued without warning or due process. She was not even given a reason for the first 2 years, and now, 4 years later, she has still not seen or heard from them. When she learned from academic and pediatric reports that they were missing almost half of school and ceased to grow even 1 inch in 4 years, which is extreme failure to thrive, she was rather barred from her constitutional right to seeing their records. In her case, she did not even report child abuse. The children simply kicked, screamed, and tried to commit suicide rather than go to their father, who almost killed each of them by head injury. Yet, he now has sole exclusive custody, and no prior adult who cared for them can have access to them. As shocking as this may sound, her case still counts among the milder ones I have seen. I do see some of the more severe ones, being a violence expert. But that is what had me delving into family court cases, and I can tell you it has not been easy to enter them, because the judges will usually wish to resort to their own experts who usually don't go beyond a master's level training. And doctorate level experts are used to be quite rare, are increasingly more distressingly part of it. Many loving parents are also professionally and financially ruined, charged exorbitant fees for evaluations, therapy, supervised visits, and child support, and then incarcerated when they cannot pay. If they try to fight back or to use the legal system as it is intended, they are retaliated against. Transferring custody allows the perpetrator to conceal his abuse, as well as to achieve the goal of tangential spouse abuse, which is abusing the children to torture the spouse. In my sister's case, she experienced 10 near-death episodes from stress and went from superior functioning as a former high-level government executive to requiring round-the-clock 24-hour care after an intensive care unit admission. I've seen courts and court appointees fish for pseudo-theories to try to justify these abrupt transfers, and this is where parental alienation and reunification come into play. Family courts have essentially produced opportunities for an entire industry of theories and methods unheard of outside of family court. Reunification camps can charge up to $40,000 for 5 days in a rundown motel. And I've personally seen a master's level so-called expert charge $500,000 for a report that was fraudulent in my view, labeling the healthy, loving parent mentally ill after just 15 minutes of interview and then permanently removing the child on that basis. And again, these situations are not so rare. So when there is child abuse, the most critical mitigating factor is the loving, protective parent. But contact with that parent is often severed for many years, if not for the child's entire childhood. The oxymoronic reunification therapy, usually done with an actively abusive parent, is contraindicated in regular mental health practice. These family court confined practices maximize harm and not only embolden existing perpetrators, but generate new ones, since roughly 1/3 of victimized children move on to become victimizers themselves. These are the reasons why I have called family courts one of the deadliest places for women and children. Men can be victims of the system as well when mothers abuse. For this reason, I've come to call family courts an abuse industry. Almost 100,000 children per year are being gravely harmed, which brings in, for family courts, more revenue than all other courts combined. Countless loving mothers have died prematurely without prior health conditions or are beset with diseases unseen anywhere else in medicine. It is a serious public health problem that, unless immediately and profoundly reformed, will continue to cause great damage to our society and our collective future. I'm very grateful for your work. I appeal to every member of this august body to enact bold legislation that can help save the 100,000 children who are sent every year to fates worse than death, what psychologists call soul murder, not to mention the loving parents who are punished for the high crime of loving their children. You are pioneers in a critical movement, and your decisions will set the standard for the entire country to follow. And it certainly helps someone like myself, who trained to become a healer and has discovered a system that will counter any effort that we try. Thank you.
Thank you, Ms. Lee, for your testimony.
Senator Finchem. Please introduce yourself and thank you for coming to our state today.
Thank you very much, Madam Chair, members. If you don't mind, I'm probably going to exceed 3 minutes, but I've got a rather lengthy document that I've furnished a copy to each of you on.
We have that.
What I'd like to do is kind of recount what Arizona has already been through, which may help to inform you of whatever path you might like to take. Madam Chair, members of the committee, I'm State Senator Mark Finchem from Arizona. Thank you for the opportunity to testify in front of your committee on the topic of family court orders. What's the purpose of government? I know you guys know. I kind of doubt that the other two branches are fully informed. It's to protect the civil rights of the people. And after all, are children not people? We've heard a whole lot of discussion about lawyers, judges, parents. I think I've heard child mentioned maybe 3 times during this whole day. So the purpose of government is also not to impose bankruptcy to the detriment of families and children. After all, the resources of a family are supposed to be directed at what? Raising the children. I'm the chairman of the Arizona Joint Legislative Ad Hoc Committee on Family Court Orders. We've held 3 hearings covering over 20 hours of testimony from professionals and from families. Very similar. In fact, if I didn't know better, I would say that I'm standing in our hearing room about an hour and 45 minutes to the south by air. The earlier testimony of your judge, while informative and speaking in the language of what ought to be, did not address practice, what's actually going on. And a growing number of complaints have been made about court-ordered parental alienation, and I'll get to that. Somebody asked earlier about, is there a definition of that? It's actually come out of thin air, by the way. He spoke to protection of civil rights of the parents under the Constitution, but made no mention of the constitutional rights of children. I understand after speaking with some of your constituents, in fact, I'm getting calls from all over the country because of the hearings that we've had in Arizona, that the Meridian PD has allegedly told parents that, quote, children do not have rights. Well, I think you all know nothing could be further from the truth. One of you mentioned that divorce is big business, and I represent, is it Earhart? Madam Chair, Representative, that's a great pull quote, except I would go one step further, that child custody is even bigger. We have had a number of families, 3 to date, at the Arizona hearing, over $1 million. One over $3 million over 11 years. All based on something called a temporary order. I'll get to that in a minute too. For many months now, my office has received pleas from parents, minors, and even aged out young adults who would like to testify in Arizona but haven't had an opportunity to. And these are families and individuals from Idaho, Utah, California, Texas, and Florida, besides Arizona, about what appears to be a growing abuse of power in the family court systems. Clearly, we have learned that this is not just an Arizona problem, but rather a systemic issue rooted in the concept that family courts should be viewed as super parents and superior to the legislature, by the way. Whenever I hear the word rule, and I'm sure you probably have the same reaction, I hear something that is not legislative law, but perhaps ought to be. The superior nature of the legislature is that you make law, not the courts. And the legislatures have not granted such power to the courts, but the courts have taken considerable liberty in assuming that role. In fact, the courts seem to have taken on the belief that they are indeed super parents and have adopted what's called pole star mindset collectively. Pole star basically equals the ultimate guidance of motivation for the court's decision in family court. It's the adhesive, if you will, the glue between statute and discretion, and the court's employment of the use of the words within the statute. And to explain the concept, pole star basically, for the constitution of a contract in contract law, is the intention of the contracting parties is expressed by them in the words they have used. And that's Ames v. American National Bank. And I've got all the citations in the document that you'll be receiving. It's really important to understand this idea because Justice Thomas uses that in a Supreme Court case. By which the court, the pole star by which the court has led to a decision is supposedly in the child's best interest. But we have heard a great deal of testimony today that perhaps it's not really, that it's an opinion of one person, and that's the one on the bench. The court uses the term pole star interchangeably in a number of different fashions, but the court has applied its mindset in Hayes v. Gamma to say that the child's best interest is the primary consideration, or the pole star, that north star, that true north concept. So it's amazing that when reading all of these case citations and reading through the case law that involves them, employed terms or instruments, the idea, the presumption, or even appearance emerges that the judges have some divine authority to decide what's best for the child. Quite often ignoring evidence, but going on the opinion of one person. Legal decision-making in the best interest of the child, which is an objective standard that prevents discrimination and preferential treatment through the use of objective evidence, ought to be that place where we go. But quite frankly, it's not. It's a very subjective thing that you've heard ample testimony about today. The courts in multiple states have come to rely on a fringe psychological theory known as COBE. And if you haven't received that yet, you're going to be pitched that to make it part of your law. It's court-ordered behavioral intervention. Now, we have on staff in Arizona a former family court judge who I think described this best. He said, well, if you think the court can order behavioral intervention and it's going to work, you might as well take $95,000 of cash, put it in the middle of the courtroom, light it on fire, because you're going to get the same result. You can lead a horse to water, but you can't make him drink. So this fringe theory and its practitioners, which frankly the whole concept flies in the face of the commitment by nearly every legislature in America to safeguard the best interests of the children, or the child, the minor children. The commitment seems to have morphed into the best interests of one of the parents in a perverse notion that forced reunification will accomplish what natural organic relationship building can achieve. The fact of the matter is it can't, because pressure breeds what? Resistance. Anytime you force somebody to do something that is against their nature, you yourselves are going to experience this. It doesn't work. These practitioners claim to be experts in their field. Yet terms like forensically informed and therapeutic interventionist are fiction created in the academic world and not the regulatory sphere. Look for that in your behavioral regulatory framework. Those phrases don't exist, they're unregulated. That means they don't have a standard of practice. No wonder they don't accept insurance. Because to accept insurance, you have to have a standard of practice by which you can judge, and that probably is where we see quasi-judicial immunity arise. We have that in Arizona, which originally in common law, the expectation is that is for people working in the court officers. Well, when the court abdicates its responsibility and assigns that responsibility into a psychotherapist or whatever, now they're relying on somebody who is not operating within a standard of practice. Do you see the circular conversation that's going on here with that? In other words, they are experts because they say they are the experts, okay? And they're not challenged for proof of efficacy, except by the good doctor who was here earlier today. And frankly, she testified in Arizona. And it was earth-shattering when media started to interview her. They were quite surprised to learn of the deficiency that we have in the regulatory framework for that category of psychotherapist. But they're not challenged for proof of efficacy, that the court accepts their assessments over solid evidence to the contrary. We have heard that several times today. Now, to illustrate this point, in the case of Gutierrez versus Honorable Fox, and this is an Arizona case, which will no doubt make it into jurisprudence, which your courts will probably take a look at. Court of Appeals in Arizona, even though it's black letter law, we have section 25-403. It's called the factors law, ARS 25-403. 12 factors that the court is required to consider when making a determination for child custody. Factor number 6, and it is kind of curious the way they have these numbered, but factor number 6 is domestic assault, and factor number 8 is sexual assault. Yet in this case, the appellate court said, well, you know, the court doesn't really have to consider that in a temporary order because, well, it's temporary. Except we have temporary orders in Arizona that have gone on 7 years. So it's one of the pieces of legislation that we're looking at is trying to pen the court in, and I would urge you to do the same. Try to get temporary orders down to a minimum amount of time.
Senator, we've given you a little extra time because we know senators really like to talk.
I appreciate that, madam. I'm going as fast as I can through this thing, all right?
Well, we do want to make sure we get to everyone's testimony, but we do have some questions for you,
Okay,
I'm sure.
very good, ma'am. So with that statement, the appeals court basically chose expediency and protection of the judge or the best interest of the child. Because what happened here is this is a question of a temporary order where the child was placed with an abuser and somebody who was engaged in sexual assault because it was a temporary order. Now, I'll get on to the Supreme Court. In Justice Thomas's comments, this has to do with the United States versus Scrimetti. It has to do with the whole sex change thing. I won't belabor the point, but Justice Thomas basically came out and said, in fact, he noted in portions of his decision where the Supreme Court held Tennessee's law banning child sex change procedures, finding that said state law does not violate the Equal Protection Clause. A portion of the judge's or justice's written statement is, this case carries a simple lesson. Courts should not assume that self-described experts, key phrase, are correct. Courts should defer to legislatures over experts. That means you define what is acceptable evidence. That is exactly what the majority report in Arizona's committee is going to explore. We'll probably have a package of between 10 and 12 bills that are going to be very specific about some of the changes we make. And Madam Chair, I'd be very happy to share that with you once that's been produced. So another key statement, and I'll close with this. States have an interest in ensuring that minor patients have the time and capacity to fully understand the irreversible treatments they may undergo. This is their civil rights. Now, in this particular case, we're talking about an irreversible physical change. Mutilation of genitals, okay? But what about an irreversible effect on a child's mind? I'll close with the case that I'm very aware of. In fact, I've heard this case several times. You have an abusive father, perhaps an addiction to drugs, alcohol, whatever that may be. And you have a mother who disagrees with the lifestyle. And you have a daughter who's kind of conflicted. They want to have a relationship with dad, but dad's a drunk, abusive. But mother refuses to acknowledge that that lifestyle is acceptable. Instead, she stays silent, and she says, you need to go with your dad this weekend. In that moment, because she did not support the father's lifestyle, by definition, from some of these psychobabble providers, she just committed child abuse. It's been called that in Arizona. Parental alienation. Madam Chair, I'm happy to answer any other questions you've got. The rest of the citations are in my report to you.
Thank you so much for coming, Senator. Representative Ehart.
Thank you, Madam Chairman. Thank you, Representative. Much appreciated. Hey, I'll try to, two questions, try to keep them quick. The first one was that, and so I'm wondering, because you've had this same problem. So we keep hearing the stories of the child being placed with the abuser, you know, from the parents. Most of these, obviously, most are women, but that's not the only case. And apparently, and I have no way of determining this, and we haven't gotten to that point to look, but apparently there's evidence that has been ignored. So I'm going to go with the assumption at this point that there's evidence that's been ignored. Is there a solution to this? Because that seems criminal to me.
Senator?
Thank you, Madam Chair. Representative Earhart. That ends up being the rules that you create. I don't want to go back and recite Chevron deference, but it's interesting that the court makes its own rules, and then the court interprets its rules and what evidence it'll accept. Okay, so we have a colleague in Arizona by the name of Alexander Culloden in the House of Representatives. He's a lawyer, and at first I had a bit of an issue with Representative Culloden killing so many bills, but the reason that he gave makes perfect sense. It's because the bills included rule-making authority within the bill for agencies. Okay.
We've experienced that.
So it stands to reason, to answer your question, madam, if the court has to come to the legislature for rule oversight, you're going to set the rules for what evidence can be accepted. Now, the other question I believe you answered, Madam Chair, if I may diverge just for a moment. I think you also asked what's the motivation for
I did.
this. Okay. All right. 2 words. Billable hours.
Sure.
It's that simple. It's billable hours for the psycho people. It's billable hours for the attorneys. And if you can't hem that in and say, okay, you've got a timeline that isn't indefinite, you need to be in a box. Now, one of the things we're looking at is 180 days. Get it done in 180 days because you're going to go from a temporary order to a permanent order.
Madam Chairman, follow up?
Go ahead.
So with some of the other testimony we've heard and then a couple of things you've said, from Arizona's perspective, from your perspective, who has jurisdiction over the judges?
Senator?
That's a great question. Madam Chair, Representative Earhart, the state constitution in Arizona is slightly different than the state constitution here. There are a number of mechanisms we have in Arizona. One is impeachment. That's not going to happen because of the division, the political division that we have within the Senate. Although, in a most egregious case, I don't want to preclude my Democrat colleagues from saying, oh, I can't vote no on this because if I do, I'm going to get thrown out of office. We have some egregious cases for consideration, but you also have to have a House of Representatives that's willing to write the articles of impeachment. And quite frankly, it's got to be a pretty, in the words of Speaker Johnson, it's got to be a pretty, at the congressional levels, it's got to be a pretty egregious thing. Well, I'm at the point, Madam Chair, Representative, I think we've arrived there.
I was going to say, Madam Chair, losing one's children is pretty egregious.
Yeah, so impeachment is number one. Number two is judicial non-retention elections. Now, judicial non-retention elections, which seem to me a rather curious means to insulate oneself from being thrown out of office. Perhaps, I'm pretty sure that if you, Madam Chair, or you, Senator Eccles, propose the idea of having non-retention elections for the legislature, you would think that the world just caught fire. Okay, so the other thing we have in Arizona, which I don't believe you have, is direct recall. If a judge has been appointed, takes 10% of the polity in which that area the judge serves to get on the ballot as an affirmative recall of a judge. Now, from what I understand, you do not have that here, but perhaps the legislature might consider a referral to the ballot if you don't get some kind of activity from the courts. One of the things that we don't have, Madam Chair, and I'll button it up with this.
Okay.
If you think back to the days when we went from the one-room schoolhouse into factory learning, this individual called the principal teacher showed up. It's now the principal, but the principal teacher was a coach, was the oversight of all the teachers within that school. And over time, that morphed into an administrator. But imagine what would happen if the presiding judge of the family court system didn't hear cases, but instead sat in courtrooms and coached the family judges on their behavior from the bench, on their interpretations of law, their negating of fact. Might we perhaps see a change in behavior? Because I think ultimately the family court is not going to go away, but it certainly needs to have some more direct oversight.
I'm going to cut you off. We have almost just about over 30 minutes. We have over 15 people that need to testify, and I definitely, we're going to be having more hearings, and we're going to hopefully have you Zoom in to present around the state at other hearings and share more of your findings in Arizona, and maybe we can collaborate amongst us with ideas.
Madam
So
Chair,
thank
I
you.
welcome the opportunity. Thank you very much
Thank you so much for showing
your
up.
deference.